Okay, good morning and welcome. You guys were probably expecting Ashley Cordy on today, but Ashley's feeling a little under the weather. So I'm going to be stepping in to talk to you about the ever evolving deed restriction process. This is a topic that we have covered plenty of times before, but it's always helpful for us to get a refresher on various different aspects of the deed restriction process. And so today we're gonna get into a couple of those. If you guys don't know, my name is Noelle Hicks. I'm one of the shareholders here in the Houston office of Roberts, Markel, Weinberg, Butler, Haley. It's a pleasure of mine to be with you today. I want to give a quick disclaimer, a disclaimer that we always give, but I just wanted to remind everyone that the information that I'm going to present to you today is the law as it is on April 22nd, 2025. This presentation is not intended to be legal advice by any means, just for educational purposes. So if there is anything that I say that you have questions about or you need some additional legal advice, please make sure you consult the attorney that works with whatever community you guys are working with, and hopefully that's us. So today we're going to, again, talk about the deed restriction enforcement process, and our goals for the day are to get into a little bit of information about dedicatory instruments and how they work, just some in-depth information about those, creating and enforcing governing documents and how important that is. We will talk about a couple of common violations that you guys might see as you're out there conducting inspections. We will talk a little bit about self-help too. So if you have a community that allows for self-help, this is something that I'd like for you to pay keen attention to. And then we'll get into, at the end, some statutory requirements, some recommendations that we have for policies that kind of mimic what the statutes that we all use say, that will be helpful for communities that you deal with. So first things first, let's get into our dedicatory instruments. As you know, a lot of people, especially here in Texas, a lot of people have this idea that no one should be able to tell them what they can do with their own property. That's obviously a special ideology that a lot of us Texans have, but as you all know, community associations are really common here in Texas. And so one of the things that kind of started or initiated the community association is the desire to preserve property values, making sure that homeowners can regulate what their neighbors are permitted to do or prohibited to do. And, that kind of creates this inherent conflict. I want to do what I want to do with my own property, but at the same time, I want to make sure that my neighbors are regulated somehow. So therein lies the birth of restrictive covenants, and then in turn, the community associations to kind of help administer that plan of what neighbors should be permitted or prohibited from doing, right? That's how we get community associations. There's a couple of other things that led to the creation of community associations, but that's a conversation for a different presentation. One of the cases that kind of started all of this was Curley versus Walker back in 1922. And it kind of, from that case, we kind of got the idea that an owner burdens his land with restrictions because of the fact that a like burden or a similar burden would be imposed on the neighbor's lot, and then that would be beneficial to both lots. So some of the things you'll hear me say today are that one of the reasons why community associations and restrictive covenants are so popular or so important is because it really does help to preserve the property values. And that's a lot of the reason why people buy into community associations in general. They preserve that property value. It maintains that, community aesthetic, and make sure that you will hopefully, right, ensure that you're not living next to a person who grows a jungle on their yard and refuses to do anything to adhere to the restrictive covenants. And we all know that we have some communities that have properties that simply refuse to adhere to the restrictive covenants. And a lot of the times the question becomes, like, why would you even buy into a community where you know that there were deed restrictions? But we can't get into the psyche of homeowners today. We will just continue our conversation about governing documents. So the property code actually gives us a definition of what dedicatory instruments actually are. We can find that in section 209.002 of the Texas Property Code. And it basically just says that each governing instrument covering the establishment, maintenance, and operation of a residential subdivision would be referred to as a dedicatory instrument. So what are we talking about here? Obviously, we are referring to our dedicatory instrument number one is going to be the declaration or CC&Rs. Some of us refer to it as the DCC&Rs. We're also talking about bylaws, policies, rules and regulation, essentially anything that gets recorded in the real property records that is effective as of the date that it gets recorded, and then it becomes enforceable against all of the owners that live in the community that is encumbered by that dedicatory instrument. So that's a really good thing for us to remember, because not all documents are dedicatory instruments. Not all the ones related to a community are dedicatory instruments, but specifically the ones that get recorded in the real property records should be referred to that. And then there are some others that fall into that category, but that's a conversation for us to have with our prospective attorney, right? All right, so what's the purpose? Well, the dedicatory instrument contains all of the governance for a community association, and different documents contain different aspects of that governance. So what are the controlling documents? Well, you all know what a plat is. A plat is that map of the community, and it sets forth all of the boundaries, the property boundaries of each one of the lots. It also will let us know where there might be any easements, where the reserves are located, and things of that nature. So the plat is actually the most controlling document for a community association. In order for a community association to actually become or to exist, it has to have articles of incorporation or certificate of formation. That's a document that it gets created by the Secretary of State. And we also would create a more expanded version of that and record that in the real property records as well. Then we have our restrictions, or our CC&Rs, as I talked about before. And that will generally contain the things like use restrictions and assessments. It creates the architectural control review authority as well. Then we can go down into bylaws. The bylaws are the document that controls how the association should be governed. So essentially, you're going to find things like meeting requirements, quorum, voting, the roles of the prospective board members, what their duties are, and things like that will be found in the bylaws. A lot of times too, you will see with our community associations, there will be things like architectural or builder guidelines, which should kind of help along with the use restrictions or the various restrictions that are in the declaration. They also will generally kind of spell out what the requirements or duties are for submitting an application to the ARC or the ACC, and how homeowners are to create different applications and make it so that whatever improvements that they might want to make on their property can get approved by the ACC. You might also see some rules and regulations. Another thing to add here are policies. These are all things that would help with the governance of the community association. And the reason why it's so important to have these dedicatory instruments, I mentioned enforceability earlier. If you are able to point to a specific rule that is contained in one of these dedicatory instruments, then it kind of helps with the enforceability of things, as far as, getting a homeowner to ensure that they are submitting that application or maintaining the proper landscaping standards. But it's also really important for if we end up having to go to court to enforce a deed restriction issue or a deed restriction violation, I'm able to go to that judge and point to a specific portion of the dedicatory instruments and say, Your Honor, this is the specific issue that we're having here. This is what the homeowner has violated. And that would help, a court kind of rule in the association's favor. Not always, but it certainly will help. All right, so the next thing we want to talk about is the different state and federal laws that community associations have to adhere to or that affect the community association. This is a partial listing. This is not every single thing that could be related, but it's the bigger things, or the things that we wanted to really point to for today's webinar. So obviously we are subject to municipal ordinances here in Houston and Harris County. There are various ordinances that we have to adhere to, but then also the state statutes. And many of you will be familiar, obviously, with the Texas Property Code. Because the community association is generally set up as a nonprofit organization, then we also adhere to the Texas Business Organizations Code, specifically in Chapter 22. And then there are some aspects of the Texas Finance Code that help us out a little bit too, especially when it comes to things like interest bearing on past due assessments. Now, there are some federal statutes that we have to adhere to as well. For a debt collector, or like our office, we have to adhere to the Fair Debt Collection Practices Act when we are seeking to collect a past due assessment from a homeowner, but also things like the Telecommunications Act, the Americans with Disabilities Act, and you have probably seen some of the presentations that we've done with regard to the Fair Housing Act as well. So those will be things like emotional support animals, discrimination, those sorts of things. Those all kind of fall within the Fair Housing Act as well. So these are just some things to kind of keep in mind. There might be issues that come up that fall under these various statutes. That would be a good time for you to consult with the attorney that represents the association to make sure that the association is in compliance with the different aspects of these statutes. All right, so we have talked about the declaration or the restrictive covenants, use restrictions, and things of that nature. The declaration itself is a living document. You guys know that every 2 years here in Texas, we go through a legislative session. We're actually in the middle of one right now. And there are changes that come about all the time, every 2 years. And so that means that your declaration and even some of the other documents that I've mentioned, they need to be living documents. They really need to be capable of amendment. They have to change with the times, which is really important here in Texas because we're always having some new update. And then they also have to change as technology changes. And we really saw how that impacted us during the COVID-19 pandemic, when everyone all of a sudden had to switch over to conducting meetings by Zoom, or just the general governance of the association had to be conducted virtually. And that was kind of a period of adjustment for all of us, but we saw how important it was to make sure that we could easily amend our documents wherever possible to allow for us to use technology to hold meetings and things of that nature. Now, one of the things that we run into a lot, even though it's important that these documents are capable of amendment, we do see quite often where the declaration itself has a very high threshold for amendment, right? A lot of us have documents that say it has to require 67% approval by all of the members. Some of them say a majority of members. And so it's important that we just kind of keep those standards in mind, because of while amendment of the declaration itself might be very difficult, there might be some other ways that we can, get rules on the books and make them enforceable. And that's a conversation, again, to have with the attorney, just to kind of make sure that you're having the most relevant information and things that can be the most enforceable against our homeowners where necessary, right? All right, so I mentioned earlier that part of the reason why restrictive covenants are so important is because we want to protect and preserve property values. That is especially important in cities like Houston, where we don't have zoning. So if you can imagine, in Houston, there are plenty of areas of town that there is no zoning, and there's a residential property, and then next door, there may have been a residential property before, but then someone comes in and turns it into some sort of business. In the area where I live, in Third Ward, I see this happen all the time, where there's a residence, and then next door, someone has come in and maybe renovated the house, and now it's a law office, or it's a mediation center, or whatever. So without zoning, people really are able to kind of just do whatever they want to with their property, which includes not maintaining it if that's something that happens. So these restrictive covenants are actually really important, and it really does serve to preserve property values. I was handling a case not too long ago where there was a homeowner who simply refused to adhere to the restrictions. It didn't matter what we did. The association spent quite a bit of money in litigation attempting to get this guy to adhere to the restrictions, simply just cut his grass, right? But the next door neighbor happened to be a realtor, and I used her testimony to show that this person's property, who was failing to adhere to the restrictions, it actually did very much affect the property value. And you could see that there was a trend downward in the value of the property over the course of time, where this guy, refused to do anything to his property. So this is actually a real thing. I know we say this a lot, but it's actually a real thing. And I was able to use that. And it was actually pretty convincing to the court that property values will decline where people are simply refusing to, uphold their portion of the deal, right, when they buy into a deed restricted community. So this is actually really, really important. All right, so as we know, our dedicatory instruments generally have certain enforcement provisions, right? Usually your deed restriction, and I'll talk about, how it can be enforced by homeowners in just a moment. But in general, the deed restrictions are going to be enforced by the association through the board of directors and likely with the help of its management company. Now, there are certain rules in the property code that allow for enforcement of the deed restrictions by the community association, but mostly you're going to look to the language of the restrictions in order to ensure that the community association has that authority to enforce, right? Because what would be the point of us having this document if there was no enforcement authority? Now, restrictive covenants can do a couple of things, right? We talked about at the beginning that homeowners would like to control what's permitted or what's prohibited on a parcel of property. And so likewise, restrictive covenants can either state some action that is permitted or some action that is prohibited on properties that are within the jurisdiction of the community. And it also will let you know what persons or entities have the rights of enforcement. So I mentioned community associations absolutely will have that right to enforce the deed restrictions. But then there are a lot of times too where the restrictions say very specifically that other owners in the community will also have that right to enforce the restrictions. It will be very clear also about what portion of the restrictions that other homeowners have the right to enforce. So what are some examples of these restrictive covenants that I'm talking about? I'm sure we've all seen these kinds of things, but it's always good to just get a little refresher about what we're talking about here. So it can, an example of a restrictive covenant is that it can prohibit non-residential use of property. Now, this can refer to things like short-term leasing, like Airbnbs, things of that nature. And actually now there are so many different services that people can use their house for. Airbnb, people can use their house to rent it out to let people shoot video productions. You've heard of Swimly, where a person can rent out their pool to random strangers, which sounds really weird to me, but some people use that as a source of income. Things like Turo, where people are allowed to come onto properties and rent someone's car. So there are various examples of non-residential uses of property that I can think of, but this is an example of one of the restrictive covenants that we're talking about here. There's also been a lot of case law and a lot of litigation related to non-residential uses of property and making sure that the language in the restrictions is actually as clear as it can possibly be about what that non-residential use actually means. And courts have actually found, especially the Texas Supreme Court has found, that in order to make sure that the association has the authority to restrict non-residential uses of property, that language needs to be really clear. But if it's not there, then the best, most effective way to ensure that that can be prohibited is by amending the declaration. And I mentioned that that can be a very high threshold. Getting 67% approval of the members of a large community or even a smaller community, because sometimes we have issues with, community engagement, can be difficult, but it is something that, the courts prefer, obviously, for us to actually get that amendment. There's also examples of prohibiting multifamily occupancy. So this also can kind of fall into the Airbnb category, but we are also talking about duplexes or, fourplexes and things like that here. We can also, imagine that multifamily can mean literally just having multifamilies living in renting rooms or something like that in a property. That's something that we can prohibit with restrictive covenants. They also can require improvements to be maintained. So you can see that this fence is falling over here. So the restrictions for this community probably say that the fence needs to be upright, it needs to be painted, or, whatever those restrictions will look like. And then oftentimes for any improvement that a homeowner wants to do, an exterior improvement, it likely requires some sort of approval by the architectural review committee. So that would mean that the homeowner needs to submit an application with all of the required information. Perhaps that means submitting a paint sample or submitting the type of wood that they would use to restore this fence that we see here in the picture. But obviously the entity with the architectural review authority, whether that's the ACC or oftentimes that could be the management company, should want to ensure that whatever they approve maintains the harmony of the exterior design of the community and the colors in the area. So a lot of times we see guidelines or, builder guidelines, design guidelines that are very specific in what sort of paint colors can be used, what sort of wood can be used for things like fences. Perhaps they don't require any approval if you're just replacing it with the same type of material that you would use in the past. So those are all things that you would need to look very specifically in your governing documents to make sure that you're aware of what that is. This is also a good time for me to plug the importance of your architectural review committee or your architectural control committee. Having a very good understanding of the governing documents and whatever the use restrictions are and whatever guidelines they should adhere to as far as, when they get an application, what to look for and what is approvable in the community. I recently had a situation where the architectural review committee failed to recognize that the homeowner submitted an application with a setback in order to put a shed in the backyard or whatever. The setback was only 8 feet, but the documents actually required 15 feet from the side property boundary. But the application was approved because no one actually caught that. And so it's difficult in that situation to kind of undo that mistake. Especially in this situation, the homeowner had already initiated the construction and built and poured a concrete slab. I can tell you from experience, courts are not likely to require a homeowner to break up and move a concrete slab because that would create more cost to the homeowner. So that's kind of a difficult situation to be in, but ultimately you just got to make sure that whatever is being approved is actually approvable pursuant to what the restrictions say, right? So make sure you take, good care to ensure that the Architectural Control Committee has reviewed the governing documents and that they just kind of know exactly what should be approved and what can't be approved. I see that there are a couple of questions that are being put in the chat too. I will get to those at the end, and maybe some of them will be covered by the time we get through the rest of the slides. So I mentioned also, we've talked a little bit about enforcement by community associations. In addition to that language being in the restrictions, there's also a section of the property code that can be referenced if that language is not in the restrictions, which sometimes we have our older documents that may not have that. So we can look to section 202.004 of the property code, which gives the association the authority to initiate, defend, or intervene in litigation or any other administrative proceeding that would affect the enforcement of a restriction. So if the language is not contained in the restrictions themselves, then we have backup in section 202.004 of the property code. All right, so this is a really important aspect. When we are enforcing our restrictions, we want to keep in mind the association's ability to recover their attorney's fees, right? So if there becomes a situation where all of the efforts that the association itself has made fall on deaf ears and the homeowner never responds to the association, they never correct the violation, never do anything, then we need to make sure once that file is being transferred over or turned over to an attorney's office, that all of the preceding conditions, or what we like to refer to as a conditions precedent, have been met so that the association can recover its attorney's fees. Now, there is a provision in section 5.006 of the property code that basically says that any person or entity that files a lawsuit relating to the enforcement of restrictive covenants and they win, then they are entitled to reasonable attorney's fees. But there's also a section of the property code that gives us a couple of other things that we have to do in order to actually recover these attorney's fees. So keep this in mind. And as we go through the rest of the slides, I'll let you know what the rest of the steps are. A lot of you probably already know, but again, this is going to be a good refresher for us. All right, so also I mentioned earlier that the restrictive covenants themselves can be enforced by owners. So not only can they be enforced by the association, but they can also be enforced by owners. There are some situations where I'm presented with an issue that's going on in the community, and I have recommended that we let the owner know that they have the same rights as the association does. So in a situation where an owner is bringing up a deed restriction violation that they've seen or some dispute that they're having with a homeowner, their next door neighbor or something like that, it may be appropriate for us to remind an owner that they have the same enforcement authority that the association does. Now, you got to be careful with this though, because use discernment here. Because if you know that this owner is going to not only sue the homeowner, but then they're going to sue the association, this is not something we want to get involved in, right? So I would consult the association's attorney before I make this recommendation. But also remember that owners have the rights to enforce use restriction or maintenance related items, but they cannot enforce the lien rights in favor of the association or any rights that are related to the collection of assessments that the association only has, right? Your governing documents will usually say this, but this is just something to remember. So someone's neighbor cannot go and file a lawsuit against them for failure to pay their assessments. That's a right that only the association has. So just keep that in mind when you're thinking about whether or not you would let a homeowner know that they have the same enforcement rights as the association does. Interestingly, though, the association also there's this presumption of reasonableness, right? So section 202.004 of the property code is very clear about the association's discretionary authority and how they can use it. And this is related to the enforcement of restrictive covenants. Now, keep in mind that there is a presumption that the association's exercise of its authority to enforce the restrictions is reasonable. Now, the exception to that is a court can determine that exercise of discretionary authority was either arbitrary, capricious, or discriminatory. So in general, courts will give the association the benefit of the doubt unless the owner who has filed a lawsuit against the association in the situation can prove that the association acted in an arbitrary, capricious, or discriminatory way. Well, how do we know what any of this means? Because the words arbitrary and capricious, if I had not been a POA attorney, I would never have heard the word capricious in my life. Basically, the definitions of these words are if the association is just enforcing the restrictions willy-nilly. So they only enforce it against people who aren't their friends, or on Tuesday they decide to enforce the restrictions, but on Friday they don't do it because nobody goes to work on Friday anyway. Or if they have not exercised good and honest judgment in their enforcement of the restrictions, these can all be considered arbitrary, capricious, or discriminatory. Now, sometimes you might have heard where a deed restriction violation is going on, a homeowner might file a counterclaim against the association. And that counterclaim will allege that the association has enforced the restrictions in an arbitrary, capricious, or discriminatory way. So that's a defense to, the homeowners or the association attempting to get the homeowner to correct some violation on their property. Well, the homeowner would then have to prove to the court that it was arbitrary, capricious, or discriminatory, right? And how do they do that? Well, they might have to conduct some discovery to find out if the association has enforced the restriction, and let's just say that this is a fence restriction, against every homeowner that had a deteriorating fence in the community. And if they're able to prove that for the most part, maybe 20% of the homes in the community have a fence that's falling down, but they've only chosen to enforce the restrictions against one of those homeowners, then that might fall into this category of arbitrary, capricious, or discriminatory. The problem with this is, though, that oftentimes homeowners have no idea that the association is making efforts to enforce the restrictions against other property owners, because homeowners are not entitled to know what efforts the association is making. They're not entitled to know the deed restriction violation history of other homeowners without a court order. So this is a difficult burden for a homeowner to meet, but it is something that I see quite often in litigation. This is actually the most common defense that I see in litigation from homeowners, saying that the association is just, enforcing the restrictions however they feel like it, and there's no rhyme or reason to it, no pattern or plan, and they just, they're discriminating against me. But this is a difficult defense to prove. There are some other defenses that homeowners can bring up. You have probably heard the statute of limitations one. So in Texas, the statute of limitations for bringing a lawsuit for a deed restriction violation is 4 years. That is also the same for the collection of assessment. So, make sure we're keeping aware of that. But also we need to keep in mind the discovery rule. So there is a chance that even if a violation has been present on a property for longer than 4 years, if the association has just discovered it, and if they had no clue before that it was present on the property, then there's an argument to be made that it is not outside the statute of limitations. There's also a defense to an equitable action. So this would make it so the association couldn't enforce the restrictions or couldn't seek any sort of monetary damages because they took so long to try to enforce the restrictions. This actually has to be a situation where the homeowner relied on the association's undue delay, meaning that it just didn't think that the association was going to enforce or didn't think it was paying attention. All of these can kind of be used together because they're similar or they are all kind of intertwined. Another argument to be made is that the association either waived or abandoned its right to enforce the restrictions. Now, waiver is interesting because it kind of goes along with the argument of arbitrary and capricious. Essentially, waiver is that the association has allowed so many violations or similarly situated violations within the area to go on unchecked, that it amounts to an abandonment of the covenant itself, or that there's some sort of change in conditions in the community. So it's no longer possible to enforce the restrictions to a substantial degree, or that, enforcing the restrictions doesn't benefit the homeowners anymore. So this can be part of the waiver argument. And there could also be a different kind of waiver, right? You can waive the provision, like one specific provision of the restrictions, or you could, argue that there's a waiver of the entire restrictions. And kind of the standard that the court would look at is, would a reasonable person conclude that the restrictions have been abandoned based on the number, nature, and severity of other existing violations? So earlier I mentioned about the fencing violation. If a homeowner can prove that 20 to 30% of the properties have a fence violation or some other violation that has not been, no notice has been given to a homeowner to correct it, or there has been no enforcement efforts whatsoever, then it's possible that this waiver argument could prevail or could succeed. But generally, it's very difficult to come up with these sorts of arguments because it's hard for a homeowner to prove that so many properties have gone unchecked, because again, they just don't understand what the association has done in order to try to get the homeowner to adhere to the restrictions. So again, this is a difficult defense to try to prove up, but it is one of the ones that we see quite often. So let's get into a couple of the common violations that you probably have seen. A lot of times it is a landscaping or lawn maintenance violation. Some exterior violation, like a homeowner has not cleaned off the siding, or cleaned mold and mildew off of the side of their property, the side of their home. Maybe they have initiated a project without the proper approval. We also see a lot of times parking, especially for communities who have like the narrower streets, where a homeowner has parked their trailer or boat or an RV on the street in violation of the restrictions. Trash cans is one that we see a lot. And then also nuisance annoyance. There's generally a very broad nuisance provision in the restrictions. Nuisance alone is not something that I would file a lawsuit on, but I would couple nuisance with things like, parking a trailer in the street and blocking another homeowner's exit from their house. They can't get out because this trailer is making it, it's parked right in front of their driveway, so they can't get out. Or, someone has put their boat trailer on the street and emergency vehicles can't get by or something like that. So I would couple parking with nuisance. A lot of times it's very good to kind of just look at the violations and use some discernment. I would not recommend, for example, filing a lawsuit based on trash cans being out on non-trash days, because it's too easy for a homeowner to go out and remove those trash cans really quickly. And so what generally happens is, if we send a letter from our office, and even if we get to the stage of filing a lawsuit, before we can actually show them pictures of the violation, the homeowner will go out and move the trash cans. So we have to kind of use our discernment of that, make sure that the association is willing to kind of go all in on these things, and making sure that they have the funds to do that, right? Because ultimately, at the end of the day, who's paying for the attorney's fees or the legal fees for enforcement of the restrictions if the homeowner just kind of spaces out on correcting their violation? It's the other homeowners. So we want to make wise use of the association's money as well, and not just go after things that, just because it's a violation. We want to use a little bit of discernment. And that's where your attorney's advice and expertise will really come into play. Now, there are some communities, not all, that have a self-help provision in their restrictions. Self-help essentially just means that the association, after notice, can go onto a homeowner's property and cure the violation themselves. Now, a lot of the restrictions will say that, the association can go onto the property and do anything that they need to do in order to cure a violation. While that language is great, it is not the most practical. And I personally would recommend that the association, again, use some discernment on what they intend to do. So, for example, if we are going to cut the lawn, do some sort of lawn maintenance or something, then that's something I would be okay with. Or if we're going to secure a dangerous condition, then that's also something that we would be okay with recommending. But we don't want to recommend to communities that they go and conduct some sort of major renovation project, or even really touching the residents at all, unless there is something that is inherently dangerous to the rest of the community, because we don't want to open or expose the association to liability. So generally, if there is that authority in the governing documents, it will also be accompanied by some notice requirements. The general amount of notice is 10 days. There might be some provisions that allow for more or less time, but you do want to make sure that that homeowner gets at least 10 days notice, and that notice gets sent by certified mail so that you have tracking information. And again, you want to kind of look at the scope of self-help. Now, the restrictions again might be very wide and broad and might say that you can do all sorts of things. But what you don't want to do is set the association up for a lawsuit. So you might want to just kind of look at the difference between what they can do and what they actually should do. Now, another thing that you really want to pay close attention to is the cost of self-help. Obviously, for the association to call out one of its vendors to cure some violation on a homeowner's property, that's going to have costs associated with it. You need to make sure you look into the governing documents and determine whether or not those costs are secured by the association's lien or not. Of course, those costs would go on to the homeowner's, their owner account. However, you got to determine whether or not they're secured, right? And of course, that notice that you send out to the homeowner is going to let them know, if the association does in fact have to go out after 10 days and hire a vendor to correct this violation, that you, the homeowner, are going to be responsible for whatever costs are associated with it. And then you also have to just, be cautious, because we live in Texas, and we are, people have their weapons and things of that nature. And so if you have sent out that notice and have scheduled a time, and no, you've gotten no response from the homeowner, you've scheduled a time for the vendor to come out and correct this violation or do whatever it is they need to do to, do the lawn maintenance or whatever the violation actually is. If the homeowner comes out and tells the association and the vendor to get off his property, then you need to go ahead and turn around and get off the property, because we don't want the situation to escalate and, put anyone in danger or in harm's way. So just kind of keep these things in mind with self-help. Not every community has the authority for self-help, but if you do, pay close attention to the provisions of the restrictions and what gives you the authority to do this. And then maybe have a conversation with the association's attorney about what is appropriate to do and what isn't. All right, so I mentioned earlier that the association had a couple of conditions precedent that it needed to meet before it could recover its attorney's fees. So we are all familiar with the 209 letter. Now, the provisions of the property code that are relevant to this are section 209.006, where it tells us exactly what our 209 letter should say. And the title of that section is notice requirement before enforcement action. So essentially, before the association can initiate any enforcement action, which would also include suspending an owner's right to using the common area, filing a lawsuit or anything like that, charging them for property damage, or even levying a fine if the association has fining authority. then this notice absolutely has to go out. There are specific requirements for this notice. We'll get into that in a different presentation, but if you have questions about that, those requirements are again in 209.006, and also I would recommend consulting with the association's attorney. But this section of the property code is also very good because it sets forth different types of violation and it puts them into the category of uncurable versus a curable violation. So an uncurable violation is something that is not a continuous act or something that is capable of being remedied by an affirmative act. So if you can think of something that will probably only happen one time, the property code gives us examples. Shooting fireworks is an example of an uncurable violation. A noise violation, like a party that happens over the weekend, property damage. An act constituting a threat to health or safety is an important one to kind of keep a note of. And then also a garage sale or some other prohibited event. Those are things that are uncurable violations. And then just think about these are things that are not continuous actions. And there are different kind of requirements in the property code for a curable versus an uncurable violation, because you can imagine if the violation is uncurable, then it doesn't make sense to put in a reasonable period to cure in the letter, right? I mentioned there were two different categories. So we talked about uncurable violations. The property code also gives us examples of curable violations. So these are parking violations, maintenance related violations, failures to get approval from the Architectural Control Committee for an improvement or some sort of exterior modification. And then ongoing noise violations, things like a barking dog or some equipment or something is making a lot of noise in the backyard, whatever that might be. These are things that are curable. These are things that could be addressed. They are continuous in nature, and they are not the kind of condition that the uncurable violations we're talking about, which are in fact capable of being remedied by some affirmative action by the homeowner. So these are just two very important distinctions to keep in mind when you're sending out your 209 letters. Of course, in order to just kind of keep things simple, you could send out a blanket 209 letter, but just keep in mind it doesn't make sense to give a homeowner 30 days to cure something that just happened once. All right, so I talked about earlier that there are some other statutory requirements. So we just talked about 209.006. That's an absolute statutory requirement. We have to follow 209.006 to give the homeowner notice and also to make sure that the association can recover its attorney's fees. But there are some other things that have come up in various legislative sessions and other things that are related to community associations that we should talk about. And these are all things that we would recommend memorializing in a policy that is specific for the community that you're dealing with. So if we're talking about political signs and displays, which is something that we just dealt with last year, the election code, section 259.002 is relevant. That gives us the parameters within which a homeowner can display a political sign, right? And so it's important to kind of translate that into a policy and put it, related to this community, file it in the real property record so it's enforceable, and then along with the requirement to have all of your governing documents on a website or posted somewhere for the homeowners to see, these policies should go there as well. The religious displays policy is important. That one changed in 2021. And so another reason why I mentioned earlier that the governing documents should be living documents is because things change all the time. We also had the security measures policy and 209 hearings. Those all kind of changed here within the last couple of years. Religious displays relates to a homeowner having the ability to display any sort of religious display on their property as opposed to just like on their front door like it was before. Of course, there are certain examples, but the association should definitely have some sort of authority to regulate this. And that's where a policy comes into play because it would set forth what the homeowner is allowed to do, but also how the association is allowed to regulate that. Security measures, we've talked about things like fencing or cameras, and those all kind of fall within security measures. Again, the association cannot prevent a homeowner from putting up certain security measures, but also there has to be some sort of regulation. Not too long ago, I had a case where a homeowner complained of its next door neighbor putting in lights, big bright lights all around the home, and also installing cameras. the complaint was that the lights were now shining into the homeowner's bedroom and it was preventing them from sleeping. And then they were also making the argument that the cameras were, instead of being pointed at this homeowner's yard only, also were pointed at the neighbor's home, right? Now, of course, the lights are one thing, but it's difficult to enforce that camera issue because we aren't necessarily sure what the camera can see unless the neighbor would voluntarily give us, some sort of shot of that. So we gotta kind of dig into that a little bit more deeply, but it's important to have certain parameters for that in a security measures policy, right? 209 hearings, that's very important. Those are things that are covered by 209.007. Homeowners are allowed to request a hearing from the board. That's also something that should go into your 209 notice, letting a homeowner know that they have the authority to do that. And then for the fining policy, that recently changed as well. And so it's important now that the association have a fining policy that very specifically lists out what the fines are going to be and for what type of violation. And that's a requirement under the property code as well. So all of these kinds of things should be memorialized in a policy so that homeowners are very clear on what exactly it is that they can and can't do and what authority the association has to regulate. All right, so in conclusion, all of the rules and restrictions, the dedicatory instruments and everything, they're going to vary from one association to the next because we have, smaller associations, we have large ones, we have ones that are here in the city, more rural ones, things of that nature. So we just have to make sure that we pay attention to what our governing documents say, and then keep up with what's going on with the legislation and how it changes so that we can make sure that we are informing our communities and keeping them up to date. But also keep in mind, it's really important that anytime you are enforcing a violation, it needs to be equal for everyone. So it makes it really difficult for that homeowner to bring up the defense of arbitrary, capricious, or discriminatory. And in the end, you want to be reasonable as possible. If you know that there's something going on with the homeowner, try not to just, keep the train going with enforcement. But if you know of a situation, reach out to that homeowner and see what's going on. But keep in mind, uniform enforcement is really important, and we want to maintain that. So that is all I have for you guys. I see that there's a couple of questions in the chat, so I'm going to go look at that really quickly and get to as many as we can within the next few minutes. Oh gosh, y'all had a lot of questions. Okay, so what authority or actions need to validate the interior minimum square footage of living space when specified in the restrictions? All right, so this is a difficult one, Wade, because most times the association doesn't have the authority to regulate the interior of a home. But if it's something that's in the restrictions, I could recommend that you move forward with it and try to get the homeowner to provide you or confirm what that minimum square footage actually is. But that's going to be a difficult one, unfortunately. All right, Christine, if a homeowner paints his house navy blue, will the court expect the homeowner to remove or repaint a neutral color? And this change must be approved by the ACC committee as noted in the HOA docs. Yeah, so I feel like with something like paint, that's a lot different than maybe pouring a concrete slab. There's more of a likelihood that the court would make a homeowner change the paint color and not be as concerned with the cost as it would be with something that was more permanent, like a concrete slab. If the documents are pretty clear on that, then I would say that you could probably lean on your documents for that one. Kim asks, our deed restrictions provide the HOA with the authority to make repairs to a residence because these are townhomes, and we make a strong attempt to uniformly enforce our restrictions, but the homeowner refuses to make repairs. Finding a contractor to make the repairs to the exterior of someone's home without their permission is very difficult, and we worry that the homeowner will bring an action against the association. Yeah. How do we answer concerns from residents where we can't get homeowners to make repairs? So, Kim, this sounds like something that we might need to talk about offline because it seems very specific. If you would reach out to me, I could answer this question for you because it's going to be a little bit more intense, and I might need to take a look at the documents to see exactly what they say. All right, Biff says, would a court consider unimproved lots relevant in calculating that an association is enforcing a deed restriction regarding built lots such as house height when examining the 20% threshold? Biff, 20% was a number that I just made up. It's not really 20%, but I think that the court probably would not consider unimproved lots because if you're looking at house height, if that's the issue, then there is no house on the lot. So it's not likely that they would consider lots that don't have a house on them. How is the proliferation of motorized bikes, scooters, and golf carts affecting enforcement? It really depends on the community. That's not something that a lot of communities are dealing with. So I wouldn't say that it is widely affecting enforcement, but it probably is an issue in communities where they allow golf carts or motorized bikes or scooters, stuff like that. Barbara says, what if the self-help notice is not in the governing documents? If the association does not have authority in its documents to exercise self-help, then it should not do it. If it does have the authority to exercise self-help, then the general amount of time that I would recommend for notice is 10 days. If the declaration is silent on that, then you can go with less time, but I would recommend 10 days. If the HOA's management company fails to send out violation notices, could that create a legal argument that the HOA has waived or abandoned its enforcement rights? Yes, Roxanne, it can. The association has to follow its procedures. So there probably is some sort of enforcement procedure, or maybe that goes along with the finding policy. Regardless, the property code is pretty clear that there has to be notice sent out in order for a homeowner to even know that the association is trying to make attempts to enforce the restrictions. So that could create an issue. Yeah. Biff says, can the association use as its defense that deed restriction violations occur under developer control or another management company, and the association gets a clean slate regarding violation history every time they change the entity controlling the ARC processes? The answer to that is no. And part of the reason why is because there are always changes that go on with the association. The board gets changed every year, for example. So the association needs to make its efforts to enforce the restrictions, whether or not it's under developer control. And it does not matter what the management company is, because ultimately it's the association that would get the lawsuit filed against it if that happened. Gabby said, if the association is not gated and it has public streets, do they have the authority to enforce trailer boat from parking on the streets? That largely depends on the governing documents. I would imagine that they probably don't have the authority to tow, but they probably do have the authority to enforce a restriction related to trailers or boats parked on the street. The next question is, are all curable violations really enforceable if the remedy is severe and costly, as in the earlier slab example? Yeah, they are, right? But in the example that I gave you, there was a lot of compromise that had to go on there because the slab was already poured. So if we're not talking about something like concrete, then this might be, it might be more easily resolved. I have seen courts require a homeowner to completely tear down an outdoor kitchen that they were building. So it's not unheard of, but it's just not as likely that a court will require that. The next question, and this is probably going to be our last one, about uncurable violations. Someone may have reported the resident who was shooting the fireworks, but did you need some sort of proof? For any violation, we would need to have some sort of proof. Yeah. So you definitely need to be able to substantiate the violation, right? And that's what makes an uncurable violation difficult. But you should recommend, pictures or video or something like that. Down the line, if the homeowner that has complained about it is willing to testify or submit an affidavit during litigation, that would be helpful. But it is very important that you have some sort of proof to kind of substantiate the violation. For the rest of the questions that I have here, and there are quite a bit, if you guys want to reach out to me via email, you certainly can. My email address is nhicks@rmwbh.com. You can also scan this QR code here that has my contact information on it. And hopefully you guys reach out, because there are a lot more questions on here that I'd like to be able to answer, but we're out of time for the day. So I appreciate you guys so much for joining us. There are a lot of you on here today, and so we're really grateful. Hopefully the information that I presented to you guys today was helpful, and it can help you to kind of make sure that make it easier for you to do your jobs. So thanks again, you guys. Shoot me an email if you have any questions, and we look forward to hearing from you. Thanks. Bye.